Yes, good evening, everybody. All of you able to hear me out? Just type yes if you are able to hear me. Good evening. Yes, yes. Thank you, Jaya. Jay, sorry, not Jaya. Good. Good to see you, everyone. I think after a break of 4 weeks. Yes, because I was out of India, so I couldn't have the webinars. So now, welcome all. Aditya, Devidas, Vijay Lakshmi, Ravindra, Jasi, Jai, Jayant Kulkarni, Ritu, Sashikant, Banu, Umesh, Amit, Lignesh, RR, and Sumi. Okay, so let's start today. Type yes in the chat box so that we can start. Okay, chalo. So today's topic is gift, which is something which we know. What is a gift is simple. Then one person giving it to another out of love and affection. That is what you will find that always in the draft, when we draft a deed of gift, you will find that is very specifically stated it is out of love and affection. But then when you are giving something, just hold on. Hold on. Sorry. So when we are sorry, there is some difficulty with the internet connection. So there was an issue. Okay, let's start. So when we talk about a gift, obviously it is out of love and affection, and it is again without any consideration. So now let's understand what is a law on that. At a point of time when you gave a gift, there was a love and affection, but over a period of time certain things happened. Now you, whether you can think again that I want to cancel the gift, revoke the gift, let's understand the first. That is one part. And another part is often asked is what is the stamp duty, or whether we should go for gift of a flat instead of waiting for will and thereafter probate and the procedure. So now we'll go through what is a law on that issue on the gift, and then a decision can be taken once you understand what are the basic of these things. So now let's start without wasting any further time on the topic. Chalo, let's start. I will screen share. Yeah. Are all of you able to see the screen? Yes? Type yes in the chat box. Yes. Okay. Let's start. So gift, transfer of property acts deals with the part of gift. So now first understand, when you are talking about transfer of property acts, basically when we are talking about transfer of property act, basically it's in respect of immovable property, but not necessarily all provisions are only related to immovable property. It covers also movable property. Now, under transfer of property act, it covers transfer of the property. So what are the transfer of property? Transfer of property comes is, one is important is sale, lease, mortgage, exchange, gift, and transfer of actionable claim. Lease and mortgage, some of you may say it is not, it is not in that technical sense entire transfer, but it is also transfer of property because substantials, except few rights, all rights are transferred from one person to another. Lease and mortgage. So today we are going to discuss on the gift deed. Gift. Sorry. So now let's start. So gift. Section 122 of a Transfer of Property Act defines gift. So what are the gift? Section 22, when we are talking about gift. So first and foremost is it has to be out of without consideration. So when we are talking about without consideration, it will be always without always will be out of love and affection. So normally when we draft a gift deed, so that is a word which you will find that it is out of love and affection will be consistently coming in that. Because there is no consideration. So one is the important element is that there has to be existing property. You can give a gift only of existing property, not something you may get, you will be entitled to, you cannot give it. Fundamental thing is there is a property of which today you are owner, that is only something which you can give, not something which you are going to get. And second element is that it has to be voluntarily given. We'll discuss that voluntarily part later on, it will come. Voluntarily and without consideration. Only consideration which is there in this, that is love and affection. That is the only consideration. There is no other consideration. And third part is it has to be accepted by the donee. And acceptance has to be that during the lifetime of the donor. But if donors die before a gift is accepted, then gift becomes void. But when we are talking about a gift deed of immovable property, now we are more or less discussing about in respect of immovable property. When we are talking about immovable property, how it is denoted by acceptance is that by the donee signing it. The person who gives a gift is called as donor, and person who accept gift is called donee. So is it clear what are the element required for a gift? Number one is existing property. No spec succession or something else which you will succeed or entitled to be can be gifted. Second, it should be voluntarily and without consideration. And there should be acceptance of the gift. I hope today you are going to give me some gift, right? By way giving good review. And I want video review rather than just putting something on the chat box. Okay, we'll go further. So it's clear now. Can I proceed further? Type proceed if I can proceed. Yeah. What is the question? Once flat is given, son can gift it, cancel or without cancel. We'll come to that. Question which has come from Daneshwar. We'll come to that. Okay. Everything will come. Because a lot of questions I was getting. That is the reason I kept this topic. So now that is how is gift made. Section 123 deals with that. Gift has to be made by a registered instrument and should be signed by and behalf of donor. And it should be attested by two witnesses. But since there has to be acceptance of the gift, it has to be also signed by the donee. Why I am talking this? It has to be signed by the donee also. If you see our old draft of the conveyance, I mean to say, by the time I also came into practice, there the practice had started where both the parties used to sign the deed of conveyance. That is a transfer deed or sale deed, whatever you call it. But if you see the old draft in the old books, you will find transfer or sale deed is always signed by only the seller, because it doesn't purchaser is not doesn't have to do anything. So that is the reason only seller used to sign it and the document used to be registered. But I think thereafter amendment came in 2004 or 5 somewhere, which requires that conveyance or sale deed should be signed by the both the parties. That is why already that practice had started. Otherwise, a simple thing happens. Suppose you are buying some property, and then if you don't sign it, what was the reaction of the customer, your client? Arey, I paid so much money and I don't have to go and register a document. So the practice of both the parties signing the deed of conveyance also started long time back. But now it has become statutorily requirement. Both the parties have to sign because there is an amendment in the Registration Act. I think 2005 or somewhere. So now going further, gift deed is not required to be again like sale deed. Gift deed was also not required to be signed by the donee, the person who is accepting it. But then, unlike sale deed, where transferee means the purchaser had to pay the money, so there is suddenly you can't say there is no acceptance from him. But in this case, when it is a gift deed, there has to be acceptance, otherwise gift deed is not complete. And before he accepts it, as explained earlier, if donor dies, then there is no gift, it becomes a void gift, so it remains a property of a donor. So therefore, when we are talking about gift deed of gift, it has to be also, it should it should also be signed by both the parties, that is donor and donee, and there has to be two witnesses. I am often, many times I keep asking what are the document which requires, I think I might have asked while having this session also, what are the document which statutorily requires the witnesses, without which the document is not complete. This is one of the document which statute says which statute said requires two witnesses. And another document is that which is that another document requires two witnesses. Come on, put on the chat box. A document which is another document which requires two witnesses. I have taken this thing, webinar on that topic also. So just a hint for you. Take part, participate, so that I also enjoy conducting this webinar. Yes. Good. Yes. So will is another document which requires statutorily there has to be two witnesses. And gift also requires, statute clearly says that if for a gift deed, it has to be by registered instrument and there has to be 2 witnesses. Otherwise, for sale deed, it is not mandatory. But then when you go to registration, procedural part, it is required because at the time of registration of a document. But otherwise, it is not mandatorily that deed of transfer becomes bad or void because there is no signature of a witness. But if gift deed and will, if no witness, that is no gift deed, no will. Oh, this is property spelling is incomplete. Okay. So this is in respect of immovable property. But when we are talking about movable property, it can be just by delivery of the property. Then it's a complete. Gift deed is complete. Gift is complete. So that is not it's not required that there has to be any gift deed, a separate kind of. Okay. So it's clear. If clear, just type witness. What you will type? Witness. How ownership is transferred? Just by delivery of this. No. Someone is asking money given is just. Mohammed, I will come on to Mohammedan law also. I will come on the Mohammedan law also because that is one of the things which we'll be discussing it. Partly. Because difficulty in Mohammedan law is that it is not codified. Like Hindu law, it's not codified. But I will be coming it. Rakesh, just remind me on that. Okay. Yeah. Only Neil has given witness, type the witness. Others are what? Okay, Minakshi. Good. Okay, chalo, let's proceed further. Yeah. Then section 124 talk about existing property as and not future property. As I told you that it has to be of existing present property. And there cannot be gift of future property which you will be entitled to. So only you can give what you are owning today. You can't give something else today which you are not owning. So suppose there could be eventuality that this is hypothetical when now we are talking about immovable property. A person is suppose giving a gift by one deed to one or two person and some do not accept it. Suppose he gives a property, suppose a flat to his two sons and one do not accept it. The person who has not accepted it, to that extent the gift becomes void. So now my question, just hear me out properly to all of you, is that suppose a person A who has two sons B and C gives a flat in equal proportion to B and C. B accept it and C doesn't accept it. So now my question is, who is the owner of the flat? Should I repeat the question? Yeah, put on the chat box. Yeah, Pallavi, A has given gift to B and C, who are his sons. B accept the gift and C doesn't accept the gift. Now it's a flat. So my question now is that who is the owner of the flat? Yeah. Good. Most of I see, just answer it. What I see, you may have some thinking on that, and don't bother if you are wrong. Your thinking is wrong. There's nothing called right or wrong in law. It's perception at times. Of course, that can't be exactly like this, a perception. But if you answer wrong in that process, it's an experience. You learn something new, or your thought process you will change after that. So don't worry that you will not, your answer might be wrong. Someone will perceive that, array, he doesn't understand what I'm talking, something like that. So always take part, participate, so that it becomes interactive sessions. Okay. So now what has happened? Most of you have given a right answer. Yeah, Jigna. Yes, it can be given because it is existing property. Huh? No, that cannot be Minakshi. Something means you are going to tell that I give you gift the fruit which are going to come on the tree next year. That cannot be given. That's what law says. So yes, now coming to the question which asks, A gives a flat to B and C. B doesn't accept it. So what has he given A? 50% he has given to B and 50% he has given to C. So he has given 50% to both. So he had 100%, he gave 50 to A, B and 50 to C. Now B accepted it and C has not accepted it. So the proportion of the interest of that person in C in the flat which he had given to C has not accepted it. So that extent that gift deed is void, and that proportion 50% will continue with the A. So A and B will become owner of the flat, which earlier was only A. So is it clear? Yes, Pallavi, right you are. Umesh, right you are. Okay, good. Let's proceed. Good. Now, this is a question often comes, and that is a question of interest for everyone. I know that. Revocation of the gift. Can the gift be revoked? Is a question which often comes. A gift is given to the of a flat by a father to his son, who was at that point of time very kind and courteous with him. But once you give a gift, he totally changes. One of the example which we know of, industrialist who gave his all shares to his son, and thereafter I don't want to take it because they are my clients. So that happens. So now let's understand whether gift can be revocable gift. Section 126 is very clear. Gift in general cannot be revoked. But donor and donee, means the person who is giving the gift, can agree that an happening of the certain event over which donor has no control, the gift will be revoked or suspended. So what could be? There could be many such instances, which could be, just what is coming in my thought is this. Some new family member is not born. If it is born within suppose 5 years, 6 years, the gift is revocable. It could be anything. Means I'm just what came into my mind just while talking with you, I am telling. If that condition is incorporated in the gift deed, it could be a void. It could be revoked. Just one example which is coming into my mind. Father gives to a grandson, suppose, a piece of land, and he says that if any other grandson is born in the family within say 5 years, then he will be only entitled for the 50% and he will have to share it with other grandson. So now tell me whether it's a revocable gift or irrevocable gift. What I'm telling, father gives, not father, a person gives a piece of land to his grandson on condition that if any other grandson is born in the family, he will have only 50% share. So is this a revocable gift or irrevocable? Yes, Jay. Yes. It's a revocable gift to the extent of 50%. Why it is revocable? Because yes, Pallavi, right. Why it is 50%? Because that person had no role in having another grandson in the family. So that was not a depended upon him, those conditions. So when you are drafting a gift, think of such kind of incident. It will depend case to case basis. Let me tell you, when you are drafting a gift deed which you feel we may require revocation, be innovative, think of a situation depending upon to case basis, what are the conditions you feel that person who is giving gift should not be in difficulty. So you will have to be innovative and ensure that that is incorporated gift deed if you want to keep an open a revocation part. Then again, gift, end of the day, it's a contract. So when a contract is bad in law, the gift is also bad in law. Like it is by fraud, by undue influence. So whatever the provisions of that contract act comes, all the provisions will come also in the gift deed, will be applicable to gift deed also. So if those conditions are some element of fraud is there, mispresentation of that, so all those things if are there, then certainly you can revoke the gift. So it is not something absolute like any contract. For in that case, if there is something elements are there which can make a contract, if which will give an opportunity to make a gift void, then it can be void. So element of fraud, misrepresentation, separation, whatever is there, then in that case, yes, it can be revoked. So then what is the process which can be revoked? If a person wants to revoke the gift, sorry, just hold on. what he will have to do? There is a deed, gift deed he has given to his son or something like that. There are things have become that he discovers some fraud, something he discovers which has been done by his son. So now he wants to revoke it. So what is he going to do? How he can revoke the gift? Just tell me. Put on the chat box. And if someone wants to speak, let me know. Rakesh or Pallavi will unmute you. Yeah. Is it clear what I told? What is he going to do? Now, certain things have become, the gift has become revocable. And what is the donor going to do? Yeah, Minakshi. The question, Aditya, is this: gift has become revocable gift due to the events discovered later on. Gift has become revocable. So what will he do? Suppose he has given a flat to his son, and then he discovers that it was obtained by XYZ fraud. I don't want to give what could be the fraud on that, but that is assumed. Let's for our discussion, there is some element of fraud was discovered by his father. So now he wants to revoke it. Yeah, Jay, that's what I'm saying. He can revoke, but how is going to revoke? Yeah, understand. But there is a transfer deed in respect of this. Now I am talking. Son is non-cooperative. How can that gift be revoked? Okay. See, first thing is that there cannot be unilateral deed of cancellation. Unless both parties agree, yes, there can be a deed of cancellation. Otherwise, there cannot be deed of cancellation. So, in such circumstances, in this case, the father will have to file a suit for revocation of gift, for declaration that he has revoked the gift by XYZ method, and the declaration that gift is void, and you will have to file a suit for that purpose. There is no other way. If sons means, I mean to say, if son is non-cooperative, means donor is non-cooperative. Only way out is a declaration of gift as void because XYZ reason. No way out. Yes, Aditya. He has to approach the court for declaration that gift is void and bad in law. So is this clear? Can I proceed now? Type yes. Good. Today we have come. So now what is owner's gift? Owner's gift is gift which is given with some condition. This could also be one of the reason for revoking the gift. Suppose he gives a gift, suppose of a 2 flats. And he puts some condition in respect of 1 flat that he will have to do XYZ, he will have to take care of father, mother, whatever it is. So he puts that, but in respect of other flat, he doesn't put any condition. But gift deed is under a single document. When gift deed is in single document of several things to same person, then in that case, a donee will have to accept it as a whole with the condition what it is given. So when we are talking about gift, could be, this could be one of the ground for revoking the gift given by father to his son. If he gives a put a condition that you will have to take care of me during my lifetime. If it is single transfer, if he transfer 2 flats to him and puts a condition that in respect of 1 flat that you will have to take care of me, then unless a donee accept it as a whole, there is no gift. But if there are 2 separate deed is made, which is independent transaction, then in respect of one, it's a complete gift, and in respect of other where he's not accepting it, there is no gift. So this is one of the term which owner, if it's a gift is onerous, then again it can be also revoked. Similarly, same thing will happen in case of a onerous gift is supposed to be given to a child, means who is at that point of time is 15 years old, and there is a condition that he has to take care of that person for his lifetime, or something onerous condition is there. The person, when he becomes qualified, means the person whom the gift is given becomes qualified, was disqualified at the point time when the gift was given to him. He was not qualified, he was 15-year-old qualified, he was not qualified to accept the gift, or accept the condition, rather not gift, condition. But once he becomes 18 and he becomes aware of it, in that case he has a choice to accept it or not to accept it. Then once he retains that gift, it becomes his obligation to fulfill the condition which is given. So I will read, Mohammed, what you are written. I think you have written quite a lengthy this thing. I will read it. So onerous gift, if it is that onerous, it has to be, acceptance has to be unconditional. If not, there is no transfer, there is no gift. Any question on this? Yeah, Devidas. When they leave, parents will leave it in that flat, Yeah, you mean to say, Hitesh, you are telling that during your lifetime, or that gift is revocable or irrevocable? According to me, basically, you are taking this. Yeah, basically, Hitesh, you are telling that this is a gift. Father gives a gift to his daughter on the condition that he will have to take care of me, or he will have to permit me to live in that flat for in my lifetime. So according to me, that is a revocable gift is if his daughter tries to drive him out. Basically, what has father done is that he has created a life interest, not life interest in the daughter, but he has made it a revocable gift. If tomorrow daughter tries to throw him out of the house, then he can always revoke it. Good question. I will just read what has Muhammad has put. Suppose both son and daughter are working. Contention is that son will say, let daughter contribute towards. Contention is son will say that let. Rakesh, just see someone is speaking. Just keep that in the. Put it in the mute. If daughter contribute towards the house, if daughter is contributing, then she may demand equal share in the. I observed that many issues. Remember, they are from Muslim community. Can it be allowed or will? Suppose both son and daughter are working. Contention, son will say that let daughter contribute towards the house. If daughter is contributing, then she may take equal share in the property. I have observed that many issues. Remember, there are Muslim community. Can it be allowed or will dispute arise after demise of both the parents? We'll discuss it. I think for me it is not very clear what is your question, but we'll unmute you up later on, Mohammed, and we'll discuss it. So owner is gift. Is it clear to everybody, or you have some question on that? Yes. Any question? No, Pallavi, they cannot unmute themselves. It's only on the beginning it happens. Just unmute him.
Good evening, sir. I am Mr. Devdas.
Yeah.
I have gifted my flat to my sister.
Okay.
I have gifted a flat to my sister.
Okay.
And the flat is on the ground floor.
Okay.
I am staying on the fourth floor, which building is not having the lift.
Okay.
Now my mother is 85 years old. She is staying with me. My mother is staying with me, and every week I have to take her to the hospital.
Okay.
So she cannot climb or get down from the without lift building. They have to take the help of 2-3 persons.
Okay.
I requested my sister, please look after her. I'll pay whatever the expenses because you are staying in the ground floor. But she's not responding.
Okay. See, if that had been your condition, that you have to take care of your mother or allow her to live in the flat, that's one question come. Then that could have been a revocable gift because you are not fulfilled the condition.
Yes, sir.
But since
I have not put the condition.
So then that is an absolute transfer has taken place once she has accepted your gift. So that has become absolute transfer. Yeah, Vijay Lakshmi. Yeah. Pallavi, just unmute Vijay Lakshmi. She has raised the hand. Yeah, Vijay Lakshmi.
Can you hear me?
Yeah, I can hear you.
Right. So, this question which this gentleman just put across to you with regards to revoking the gift deed. Now, if she is a senior citizen, isn't it possible to do so? Because under this, under the Senior
Domestic
Citizen,
violence, I think, which
no,
Domestic Violence Act, right?
no, the Senior Citizens Act,
Senior
the
Citizen
maintain.
Act. Yes,
Yes,
yes.
can't you do
No, no, yeah, that's what I was looking at it, but I couldn't look into it. I was just good that you reminded me. I couldn't look into that act, but I think there
that?
are
Yeah. So
certain provision in that, but I couldn't get a time
no,
into.
so I just want to ask the gentleman if the gift was made after 2005, 2007. Sorry.
Huh. So that, see again, that is something which I mean, I tried to check out some judgment on that, but unfortunately I was not able to get it. But I read it, but I was not able to get it. Good, Vijay Lakshmi. Thanks for putting that question.
Yeah, yeah. Okay, thank you.
Yeah. Yeah, Hitesh. Yeah, unmute yourself.
Hello.
Yeah.
Sir, what is better as per your opinion if the parents are there living in their flat and they are having three son and daughter? One is non-cooperative and other they, means father want to give the gift to their two child and they are knowing that third child is not cooperating. So what is better, by will they can transfer or by gift as a conditional gift to their child? Because see, they want to live in this flat up to when they are living.
Yeah. So in their lifetime, they want to continue to live. Yes. See, the two thing aspect which you will have, I will have to understood. When you are giving a gift, it is an immediate transfer at present.
Okay.
Could be on certain condition. When we are putting a conditional, those could be one of the conditions that I should be permitted to stay and all those things in the flat. So there could be some condition. So it's a conditional gift. But then we'll come to the stamp duty aspect also. If stamp duty is applicable, then if applicable, then you will have to spend for stamp duty. If we consider a will is something which will take place later on, and again the difficulty which arises is in respect of probate and all those things, because now the Maharashtra Cooperative Society with the amendment more or less at that section little bit doubtful, but more or less made it mandatory that there has to be a probate of the will.
Okay.
I mean to say probate or this not letter of succession, heirship certificate. So the kind of time which is consumed in all this process may be around 2 years, 3 years, whatever it takes. So that is what is beneficially. We'll come to that part also after this. Stamp duty part also will come. We'll come to the stamp duty part. So
but
now
in that transaction,
yeah, bolo.
Yeah, for that, as per your opinion, for parents, what will be the beneficial? What will be better? That will be giving gift by as a conditional gift, or to make a will and then transfer to that two child.
Hold on for 5 minutes. You will reply it.
Okay.
Okay.
Okay. Thank you. Thank you.
Okay. So universal donor, basically what is it? Two parties. Something more, Meenakshi, you want to talk?
Yes, sir. Yes, sir. Just an extension to the same question, whether the parent should have make a will or and transfer, or make it through a gift deed. If a gift deed is done, is created with two witnesses, and the transfer is done with a condition that we will stay in this house till we are alive, like father is transferring to the son, but keeping a condition that I will stay in this house. After me, my wife will stay in this house, and after my wife, son, you can take it up. But interim, the son passes away. In that case, who will be owning it?
See, understood. Because his son will be I am not bound by whatever my father gave, right? That's what you are basically saying. A father gives a gift to his son on the condition that he will permit his wife to stay in the flat during her lifetime. But his son passes away, he expires, whether that condition be a binding condition, right? That is your question, Meenakshi, right? Right? I think she has become.
Yes, sir. Exactly. That is the question.
Right.
Whether the gift will be binding.
Right. See, you have to understand that covenant of gift, it runs with the property. It's not the covenant which is with the person. Its covenant is with the property. These are the conditions with which your property is transferred. So tomorrow, it can be that that condition is not applicable to his son. His son also will be bound by that. Okay. That is a covenant which is running with the land, running with that property. So he will also be bound by it. Any third person also will be bound by that if he sells at a point of time. So that condition is with the Ravindra. Hello to everyone. Flat owned by son, parent along with sister staying in the same with that flat. Son wants to stay in that flat with his wife, but his parents and sister are not ready to evacuate the flat. Flat is owned by son and parents along with the sister staying in that flat. Son wants to stay in that flat with the wife, but his parents and sister are not ready to evacuate the flat. What are the remedies? Only remedy is you will have to file a suit, nothing else. There is no way out. You will have to file that he is exclusively entitled for the said flat for the possession of the flat. Nothing else.
Sir, Meenakshi here. In continuation to my question, can I, if the granddaughter or the grandson of the son claims that house, can they be the owner? Because the son is no more and the grandmother is alive.
That's what I'm saying. No, that condition runs with the flat. So he will also bound by that. Grandson also will be bound by the condition. He will have to permit his grandmother to stay in that flat.
Permit the grandmother to stay. Understood. Okay.
And anyone, even if he transfer the flat, that condition will be there with the flat. Transferor of the flat also cannot claim that he is entitled for the possession. He will have to also allow, means flat, how I don't know how it could be possible, but then that is a condition which is attached to the flat. To give an example to you, if a person sells a property, he has a plot of land. Let's assume that there are plot of land which is across a sea. So he sells a part of property which is touching the sea, I mean to say, and part which is behind it, he keeps to himself. So he has divided that property in two parts. One is facing the sea, and the one which is behind that he has kept with him. I am giving just an abstract example which is coming into my mind. But he puts a condition that at the time of sale, that you will not construct any building above 2 floors, because he is having a building which is of 4 floors, so that he can enjoy unobstructed view of the flat, view of the sea. So what happens in this case is that he has put a condition on the property, not on that person. So whosoever he sells the flat tomorrow after 5 years, 10 years, 50 years, that condition is attached to that property. So whosoever buys cannot build a flat or a building above 2 floors. Unless that condition is waived by the person who has transferred it or he is transferring. Am I clear what I told now? Clear? Because we have one example at Nepean Sea Road. I don't know now what is the condition. That he had told with a condition not to construct a building of more than 2 floors. And I think I had seen that building 20 years back. I don't know what is the condition because court had granted stay. No, nothing doing up to 2 floors only, that's all. So if that is a covenant which will run along with the land. Now coming to the Mohammedan law applicable to the gift. When it comes to Mohammedan law, these provisions are not applicable. So when we are talking about Mohammedan law, a Mohammedan can give his property without any registered document. And the latest Supreme Court judgment on that, I think 2-3 years ago, is just hold on. I will share with you tomorrow that judgment. That Mohammedan is not required to. It's a judgment of Hafiza Bibi versus Sheikh Farid of 2000. Civil appeal is of 2005, but I think it was disposed of in. Judgment is of 2011, but there are many other judgments also which has come after that. So when it's one is that these provisions are not applicable to Mohammedan law and they can give a gift without registration and without paying a stamp duty. Practically, sometimes it becomes a difficult issue, but that's what the law is today. So now let's go further. What is the stamp duty? So stamp duty, see again, when we are talking of a gift is nothing but a transfer of property from one person to another. So on that aspect, whatever stamp duty is applicable to conveyance or sale, same stamp duty is applicable to gift also. Hitesh will come again. I think you are raised again hand. Then, but provided it gives what? If property is gifted to family member being husband, wife, brother or sister of the donor or any lineal descendant, ascendant or descendant of the donor, that amount of duty chargeable shall be at the rate of 3% of the market value of the property, which is subject matter of the gift. So when it is given to the family members, as they are defined who are the family member. Either it has to be lineal descendant, ascendant or descendant. Then 3% is the stamp duty. But they are further given one provision. If it's residential and agriculture is gifted to husband, wife, son, daughter, granddaughter, wife of deceased son, the amount of duty chargeable shall be rupees 200. So it is, what is it? If it's a residential and agricultural property, then it is going to be 200. But this was supposed to be cancelled. Some notification was that I was trying to find out, but I didn't get it. But whatever I have extracted is from the stamp duty, this thing, which is of 22, means last year's only. So I'm not, I tried to find out, some things were going on, that is good, they are going to cancel this. But right now I'm not able to comment on that. So yeah, there was a question which whether he should right now transfer the flat or it should be transfer, gift should be given afterwards. If that is something which you will have to decide it. See, what is given if residential and agricultural property. So when flat we are talking about, it will come into the residential, this thing. And according to me, it can be on the 200 rupees stamp paper. But then if it is gifted to husband, wife, son, daughter, grandson, granddaughter, wife of deceased son, it's a fiscal statute. So there cannot be two interpretation. Only if it is comes in this category, only then 200 rupees will be applicable, otherwise not. Okay. So who was asking? I think someone was asking that whether it can be, whether he has to make a gift or he has to give this thing, will. If it is coming in this category, if you have paid 200 rupees and then close, then fine. Make a onerous condition that XYZ condition is giving the gift, or it can be revoked karke. Okay. What is it, Mohammed? Yeah. You can unmute yourself. Yeah.
Good evening.
Yeah, good evening.
You see, there are two scenarios. I'm talking in terms of I'm talking in terms of inheritance, keeping the will in front, and also the Mohammedan law. Okay. Now there are two situations. In today's time, suppose if you're having a son and you're having a daughter, both are working. And the son says that because the daughter is also working, she should contribute equally in the house.
Right.
Okay. Now, in this scenario, after the demise, before the demise, can a will be made whereby 50% share should go to the son and 50% share should go to the daughter? Will there be any dispute as far as Mohammedan law is concerned?
See, first thing, what is happening is that when it comes to Mohammedan law, there is no codification. The difficulty arises that now whatever interpretation or court relies is the commentary which is on the basis of Mohammedan law of Mr. Mullah, the author. So I think there is some restriction to what extent he can give it in the Mohammedan law. Not, I think he can't give entire property. That's what my recollection. So difficulty is there is no codification, and whatever it is done, it is based on 231 is Sharia law and something 4 I saw yesterday. I was reading through because I am working on something else on that. So it's based on 3 scriptural document of which has believed in by Mohammedan, and on basis of that, many different authors are given their comment. But certain means to certain extent there are certainty on certain part. So I think, and that I think because I have not just looked into it, and Rakesh also was working on that, there is certain extent only he can't give entire property by way of a gift or something like that is there. So I'm not really at present will be able to comment on that.
No, by way of will, not gift. by way
Yeah,
of
but
giving
I think there is some restriction on that by giving entire property. I think so. I'm not sure. I don't want to make something commitment because it's not codified. That's my problem is.
Okay.
Okay.
Right.
Yeah. Vijay. Yeah. Yeah, Vijay.
So there was the question which Meenakshi put across, in which she said that the gift is first given to the and the condition is that it has to go to the wife, and then it will go to the son, and the son passes away. Correct? In that case, when the son passes away, doesn't it just get restricted till the wife? I mean, then doesn't it become void as far as the son is concerned, because he's passed away? So where is the question of grandsons or granddaughters coming into the picture?
So okay, I got what you are trying to tell is that the gift itself has become void. That's what you are trying to tell.
Correct, because if you are telling me that you have to first, after me, it will go to my wife and then to my son, right? So the son passes away. So then there is no question of a gift, right? Because the son is not there in the picture. So then the gift becomes void, right?
See, many things will depend upon interpretation and how the gift deed is drafted. See, what is a gift deed? Gift deed is basically a transfer of property from one person to another.
No, but sir, what I want to say is that when I put a statement saying that this is gifted to my wife, and after my wife's death, it is gifted to my son, I don't think it's a correct.
Then no. Come. See, that is a different scenario you are talking altogether.
Correct,
you are talking altogether different scenario now. That is yes. Right. So now what you are saying is that life interest is created for his wife or son, whatever. So life interest is created. So life interest is created means during his lifetime he will be entitled to that. The discussion which was there was the gift is given to the son on condition that he should permit his mother during his lifetime to stay in this.
Okay, I got the question, that interpretation. My question is again to the same interpretation, that if the son only is not there in the picture, then the whole gift is void, right?
No, because there is a condition is attached to what? Condition is attached to the flat, that she should be permitted to stay there. On that basis, it is
how would a grandkid, how can a grandson or a granddaughter play a role? Is it just because it's their father? I'm trying to understand that part.
So
you understand my question, sir?
Yeah. I got your question. What you are trying to say is that with that condition, the flat is given to the son, and now son is a person who can fulfill that obligation. Who can fulfill that obligation is no more. So the gift is void. That's what you are trying to say, right?
I'm trying to ask you, sir. I'm asking you.
Yeah, that's what. This is your query, right? See, first thing is that there is a gift means there is a transfer which has already taken place from A to B.
Correct. Okay.
So there is a transfer has taken place. And there is a condition that she should be allowed to stay in that flat. Is that an obligation which can be performed by son? According to me, it can be performed. So it cannot be given. Grandson. Son, grandson. So according to me, it can be performed. That he can allow her, his grandmother, to stay in the flat. So that's the reason I gave an example. I gave an example of that building at Nepean Sea Road. Only 2 floors, about 2 floors he can't construct. So that is a dead end. That's all, nothing else.
Okay, sir. Thank you.
So, but again, if you are trying to interpret, could be, there is a matter of discussion, what is put in the document, how it is put, how someone interpret. that will all depends on the case to case basis, where what is put in the gift deed and all those things. It's 9:40, 8:40. I thought I will complete today by 8:10. Okay. So again, I am requesting. So I'm stopping this today's topic over here. And I wanted video testimonials from all of you about the review of this topic which we have discussed. And I will be grateful if you give the review also on the testimonial, video testimonial. You can send it or put it in the group, or you can send it to my personal chat also. And if not, at least give a testimonial on writing on the WhatsApp group also. And other thing which one is that I wanted to share this judgment also. Okay, I will share it judgment on the group itself. Hafiza Bibi versus this thing. Okay, then we'll stop for the day. What is that? Some chat. I want this thing now in a proper testimonial. If you put on the chat box, it would be great. At least 3-4 line testimonial. Okay, bye bye. I'm expecting some good testimonial again today also. Bye bye. Okay, I'll stop here. Have a good weekend. Bye.